Welcome back to the Church Law Podcast, where we empower church leaders with the legal insight they need to lead with confidence. I'm your host, Erika Cole, the church attorney. In today's episode, we're diving into a topic that affects every church, regardless of your size or your denomination. This one's for you. We're talking about how to maintain your church's tax-exempt status. I know that every church wants to stay focused on ministry, your God-given vision, not IRS audits, expensive fines, or losing your tax-exempt status. But too often, churches drift into dangerous waters without even realizing it. In my over 25 years as an attorney representing denominations with thousands of churches affiliated with them to brand new church plants, it's been my experience that church leaders want to do the right thing, but sometimes what that is can be unclear. So today we're unpacking what tax exempt status really means, the top 5 ways churches risk losing it, and a couple of true stories of churches that actually lost their tax exempt status so you don't have to. All right, so let's get started with this as a foundation. In the United States, churches are automatically presumed to be tax exempt under Section 501c3 of the Internal Revenue Code. That is, as long as they operate exclusively for religious, charitable, or educational purposes. So that means there's no federal income tax. As a business owner, that sounds really exciting to me, but so no federal income tax, potential property tax exemptions, and of course, donors can make the tax deductible contributions up to the limits set by Congress. But here's the catch. It may not be permanent if you don't maintain compliance. Right? So that tax exempt status is something precious that we want churches to be able to enjoy as long as the law allows. So I've completed literally thousands of tax exempt applications with a 100% success rate. So I know a thing or two about this IRS process. And as you heard me say earlier, churches are presumed to be exempt, but because you can only demonstrate your exempt status to donors, possible funders, etc., by completing the application for recognition of exemption, that's IRS Form 1023, and receiving a favorable ruling. That means you get that IRS letter of determination showing that your application has been reviewed and your application has been approved. You can only demonstrate your exemption if you've got that letter, right? So most churches find value in going through the process of receiving this letter of determination from the IRS showing that the church is exempt. Also, the IRS lists all organizations that have received tax exempt status in their publication 78. So if you have any questions about whether your church or organization is recognized by the IRS as exempt, I'll drop that link to publication 78 in the show notes so you can check for yourself. And let me just be clear, it's not every day that a church loses its tax exempt status, but you don't want to be that church that does. Right. So allow me to share a couple of cases where churches unfortunately did lose their exempt status. The very first case happened with Branch Ministries. It's the case references Branch Ministries versus Rosati. So just as a quick overview, in 1992, the church at Pierce Creek in Binghamton, New York, that's how I'm going to say that, placed full page ads in a national newspaper urging all Christians not to vote for the then presidential candidate, citing his positions on certain areas of Christian values. And the ads went on to solicit tax-deductible donations, which, not surprisingly, I don't think, led the IRS to investigate. So the IRS, in fact, investigated and revoked the church's tax-exempt status in 1995, citing prohibited political campaign intervention. The church sued, claiming violations of free speech and religious freedom. The U.S. Court of Appeals for the District of Columbia Circuit Court upheld the IRS's decision, affirming that tax-exempt organizations cannot engage in political campaigning. So that's one example. Another example is it's called Christian Echoes National Ministry, Inc. versus United States. And in this case, Christian Echoes is a religious organization engaged in extensive lobbying, political activities, including publishing materials opposing certain political candidates and legislation. Again, in this case, the IRS revoked its tax-exempt status, and the revocation was upheld by the 10th Circuit Court of Appeals. The court determined that the organization's substantial lobbying activities were inconsistent with the requirement for tax-exempt organizations under 501c3. And then recently, just in recent months, specifically several Texas churches, including Lake Point Church in Dallas, were accused of violating the Johnson Amendment by engaging in political endorsements during sermons. So again, this whole area continues to be an issue, right? So I want to go over 5 ways. I want to give you 5 ways to protect your church and avoid these challenges around tax exemption and possibly losing it. All right. So one is around this area of private benefit and annulment. So private benefit and annulment ban. You should know that a 501c3 organization must avoid all activities that will substantially benefit the private interest of any individual or any other organization. The annulment ban draws specific attention to the regulation that no insider of a 501c3 organization be the recipient of its income or assets. Now, let me just say what this does not mean. This doesn't mean that your church can't hire and pay a reasonable salary to individuals providing services to the church. But what it does mean is that people can't, like in a private organization or a for-profit entity where individuals can get the benefit of, let's say, the cash flow, or maybe it has significant year where there's lots of revenue. You don't get to share that, for example, with private individuals, right? A second example of this area of compliance that can help ensure that your church is protected from losing its tax-exempt status is lobbying limitations. Lobbying includes any activity designed to influence legislation. 501c3 organizations, and I want to be clear, this is not limited to churches, right? It includes churches. We're talking specifically about churches because it's the Church Law Podcast, but this prohibition is for all tax-exempt organizations. So any 501c3 organization runs the risk of losing tax-exempt status if the organization is found to be involved in any lobbying that is considered by the IRS to be substantial. So I will absolutely recognize that this idea of substantial can sometimes be a slippery slope for people to be able to judge by, but there are clear lobbying limitations, and churches want to be aware of that. The third that I want to mention is clear from the cases that I cited earlier, and that is campaigning ban. Political campaigning includes direct and indirect participation and or intervention in a political campaign on behalf of or in opposition to any candidate for political office. This is an absolute ban in which any violation may result in the loss of tax-exempt status and the imposition of excise taxes. So we know that churches and other tax-exempt organizations can educate people on on maybe issues that are political in nature, but direct or indirect participation in political campaigning, the IRS has said is a no-no. A fourth area that you want to make sure you protect your church's tax exempt status is this area of unrelated business income, or UBIT, unrelated business income tax. So, what is unrelated business income tax? What constitutes this is income that is earned or received by, well, let me say, unrelated business income is most income that is earned or received by a tax exempt organization, which is unrelated to its purpose or mission. So, for example, if a church receives unrelated business income, it may be required to pay taxes on such income and file a Form 990T. An example would be, let's say, a church, and I've dealt with this specific issue, decides that it wants to lease, it's have a billboard, right? So that would be an example. I represented a church that had an opportunity. They were positioned in a certain way on a major highway, and they got a chance to receive income from just having the billboard on top of their building. And that was considered unrelated income. But it's fine. Churches can make that decision to receive. And I think, quite frankly, that's a plus. But you just want to make sure that you maintain the proper tax filings for this unrelated business income. The last point that I wanted to mention about these top 5, these key strategies, is know when you have to file, and this is related to the point that I just mentioned, right? So sometimes your church may engage in some affiliated nonprofits, right? So maybe that's a school. I have a lot of church represent a number of churches that have schools associated with them, or maybe they have other kinds of like outreach organizations, maybe a CDC. These entities have different rules because they're not churches, right? Only churches are exempt from having to file Form 990. So if your church operates some affiliated entity like a school or CDC, et cetera, you got to know when to file. And those are probably key examples where you would be required to file. Now, what happens if a church loses its tax exempt status? I really love this church law and tax article, and I will put it in the show notes regarding implications of losing tax exempt status. So, losing tax exempt status would significantly impact your church. The article goes on to say in several ways, and there are key consequences. So, the first, of course, is that the church's net income would be subject to federal and state income taxation, except, of course, states without income tax, but being for sure subject to federal income tax. And I'm sure that's not the desire of any church. I mean, that's going to take a big bite out of those revenues. That's also not how donors want to see their monies used for tax exempt purposes either. Of course, speaking of donors would no longer be able to deduct their contributions to the church. The church would be ineligible to establish or maintain any 403B tax sheltered annuities. So if you've created as a church a retirement plan, then that would be lost. The church could lose its property tax exemption because many states base their tax exemption for the state property on that federal exemption. Same for the sales tax exemption. The church could lose its sales tax exemption under state law. Also, the church could lose its exemption from unemployment taxes. This just goes on and on and on. The impact is serious for the organization, but there's also impact on ministers and the congregation. So these rules that protect churches, such as rules for certain fringe benefits, would be lost. The housing allowance, which obviously is a huge benefit, could also be affected in some cases. And again, we know that congregants would be affected, or donors overall, by not being able to deduct their contributions. And I just want to say sometimes these things happen generally they're retroactive, right? Because it takes a while for cases to move through the system. So sometimes donors will have to go back and revise any of their past filings where they have taken these tax benefits to now remove them. So it's not a good experience for anyone. So I often say that obtaining 501c3 status is just the beginning. The real work is maintaining it. So from IRS compliance to annual reporting obligations and even public perception, these key legal and practical steps that churches must take to protect this designation is critical for you to be aware of. So whether you are a pastor, an administrator, a board member, finance team member, or other church leader who cares deeply about your church's mission, today's episode really serves as your ultimate guide in clarifying what it really takes to keep your church's tax exempt status in good standing. So it's not just about following the law, it's about stewarding your church's resources with wisdom, with integrity, with foresight. And to help, I'm providing you with a free checklist that your church can use to make sure that you have your seminal legal documents in place. So this checklist goes through critical documents that I would imagine all churches will want to have in place. So it's free. You can just click the link in the show notes to download and grab your copy. If you found this episode helpful, I'd love for you to subscribe, leave a review, and share it with others who serve in ministry leadership. Of course, I can't cover everything on this topic in one podcast episode, but I literally wrote the book on it. So you can grab your copy of the Church Attorney's Guide to 501c3 status, how to obtain, maintain, and protect your church's tax exempt status. It's at erikacole.com or check the link in the show notes. If you'd ever need ongoing legal support for your church, I do offer fractional general counsel services designed to keep your ministry compliant, protected, and positioned for growth. So again, learn more at erikacole.com. Thanks for listening to the Church Law Podcast. I'm Erika Cole, the church attorney, and I'll see you next time. God bless. Bye.